Welcome back, everyone, to Hocking Valley Community Hospital's 55 Ways to a Better Me. This year in 2021, we're offering 55 different ways to kind of make a better improvement in our lives, make a difference. So both in physical, financial, several different ways that we're doing this. Special guest with us today is a foundation board member as well, Abigail M. Saving. Partner with Saving and Shepler Law Firm in Hocking County, a member of the Ohio State Bar Association, the Hocking County Bar Association, and several local boards and committees. She brings 10 plus years of legal advising experience here today. Her focuses are real estate, general business law, probate, civil litigation, and estate planning. And here today, she's going to talk with us about the benefits of having a will. So welcome, Abby. Thank you so much for joining us today. And just feel free to take it over.
Absolutely. So today I want to talk with you about some of the most important reasons for having a will. And to back up and start, let's talk about what a will is. So when we're doing estate planning, there are a lot of different tools in the estate planner's toolkits. And one of the most important is the last will and testament. A last will and testament is a document that you make in order to tell the world what you want to have happen to your assets after you pass away. And you can specify in a last will and testament that you want who you want to receive the assets, and you also specify in the last will and testament who it is that you want to be the manager of the wrapping up of your final affairs, and that is called an executor. So that in order to have a last will and testament drawn up properly, you should definitely seek legal advice. But I want to go through with you some of the reasons why you might want to do that. So the first is that if you have a last will and testament, it's going to save time and money for your loved ones after you pass away. Almost all estates have to go through probate court after a person passes away. And to start that probate court process, the executor that you name in your will would meet with the attorney and go over documentation in order to have that prepared to present to the probate court. If you do not have a last will and testament, it doesn't mean that your estate wouldn't have to go through probate court. It still would. But having the last will and testament eases the legal process for your loved ones after you pass away, because it names the person who's going to be the executor of your estate, and it names those that are going to be receiving the assets under your estate planning documents. It also will give the court a picture of what it is that you want your executor to have the power and authority to do. If you don't put that in your last will and testament, then your administrator of your estate would only have those powers conferred by state statute, and it's much more limited than if you were to have a last will and testament. And what that causes is for the administrator to have to go back to the probate court and ask for permission to do X, Y, or Z, for example, to sell your real estate. And so that increases time and expense for purposes of getting your estate administered. And if you have a last will and testament, you can avoid some of those things. The second reason that it's important to have a last will and testament is one that I've alluded to already. You are using, in your last will and testament, you're specifying who it is that you want to serve as the executor. And if you don't specify in the last will and testament who you want to serve as executor, then it's your loved ones will have to make an application to the probate court, and it's not necessarily the case that the person that you would want to serve as executor is going to be the person who is awarded that responsibility through the probate court. Being an executor, it's an important job, but it's just that, it's a job. What the executor does and the role that they play is they work with the attorney's office to wrap up your final affairs, to pay all the bills that are outstanding, to liquidate any assets that are there so that cash can be distributed, or to distribute in kind if you have specifically bequested an item of personal property or devised a piece of real property to a loved one. Then they are the ones who take care of getting that accomplished together with the attorney who assists them in wrapping up the estate. So it's important that with a job as big as it is, that you kind of think about who it is who makes the most sense to play that role and determine for yourself who's going to be the person to manage your estate. And that way, you know that it will be done in accordance with your wishes, as opposed to the probate court just naming somebody that might not be who you want to do it. Another reason why it's important to have a last will and testament is, of course, to decide who it is that gets your assets in your property, and maybe who doesn't get your assets in your property. So most people are aware that a last will and testament is a document that determines who gets property after you pass away. So as a testator, which is a fancy word for saying the person who's making out the will, you name the people who will act as beneficiaries under your last will and testament, and you can give to them specified items of personal property or real property, or you can just say generally you want them to take everything that you own at the time of your death, which is called a residuary estate. So if you do not have a last will and testament, it doesn't mean that nobody gets your assets. Of course, somebody would get your assets, but it might not be those that you want. Under Ohio law, there is the intestate succession statute, and the intestate succession statute determines who gets assets after somebody passes away in the event that a person doesn't have a will. If you don't have a will, you're what you call intestate, again, a fancy legal word. So what generally happens under Ohio Revised Code on intestate succession is that the person who are most closely related to you by blood are generally those who are going to inherit from you. And that's not always the way that people want it to go. So if you have a last will and testament, you would have the opportunity to name who it is that you want to have be the beneficiary of your estate. And you can also use a last will and testament to name those that you don't want to be beneficiaries of your estate. So a lot of times when I'm working with people on estate planning documents, they have somebody that they want to make sure doesn't receive any kind of an inheritance, and we specify that right in the last will and testament so that it isn't confused by the probate court that it was an omission. They might think that it was an omission, but instead just specifying it spells it out for the court. Another reason to have a last will and testament is because it is the last will and testament that tells the probate court who you want to take care of your minor children after you pass away. If you're a parent, you would need to nominate what they call a guardian of the child's person and the child's estate if something should happen to you and prior to your children reaching the age of majority. And a guardian of the person is what you would think of when you think of guardianships. It's who has legal custody of your child's person. Guardian of the estate is the person who handles your child's financial affairs. And those don't have to be the same person. They can be two separate people, but it's the last will and testament that designates what happens with respect to your children. Another reason is because a lot of people have pets and they want to know what's going to happen to their pets after they pass away. Under Ohio law, pets are determined to be property. So you can't leave assets to your pet under your last will and testament, but you can leave your pet to a trusted loved one to be able to care for your pets after you've passed away. So those are the primary reasons to have a last will and testament. But in addition to talking about that, what I wanted to discuss with you is what is it that passes under a last will and testament anyway? So in the entire world, you can think of there as being two different types of assets. There are probate assets and there are non-probate assets. Probate assets are assets that have to go through probate court in order to go to your loved ones. Non-probate assets transfer automatically outside of the probate process by operation of law. And the distinction between probate assets and non-probate assets is entirely about how that asset is titled. Almost all property that you own is titled. Like your real estate is titled in the way that your name appears on the deed. Your bank accounts are titled in the way that your statement comes in the mail. Your car is titled in the way that's in the title document that you receive when you purchase the vehicle. If your title on your assets specifies a beneficiary designation, then that asset is going to pass pursuant to the beneficiary designation. And it really doesn't matter what your last will and testament says. It's what we think of as a non-probate asset. It passes by operation of law pursuant to that beneficiary designation. The probate assets are those assets that are titled without a beneficiary designation. And so those assets are going to pass pursuant to your last will and testament. Another aspect of estate planning that I like to talk with clients about is end-of-life decision-making. Of course, we know and think of the last will and testament when we're thinking about estate planning, but there are several other tools in the estate planner's toolkit that I like to use in meeting and talking with people about estate planning. Sometimes as we get into the later stages of our life, our decision-making ability can become compromised. And if that is the case, and you haven't made plans for that possibility, then your loved ones have no choice but to run to the probate court and ask that a guardianship be established for somebody to be able to be named to have power and authority to make decisions for you. To establish a guardianship through the probate court for an incompetent person, it's an expensive and a frustrating process for your loved ones. And it's easily avoidable if you just make a power of attorney for decision-making purposes. It's appointing somebody to be able to make decisions for you in the event that you can't make decisions for yourself. And there's two different types of powers of attorney. The first is a power of attorney for business purposes. And the power of attorney for business purposes is exactly what you would think. It's for all of the different kinds of assets that you have, your real estate, your bank accounts, your vehicles. The power of attorney for business purposes gives somebody the authority to make decisions on behalf of you for those asset classes in the event that you cannot make decisions for yourself. A healthcare power of attorney works exactly the same way. It names somebody to be able to make decisions for you in the event that you cannot make them for yourself, but it's just for healthcare decision-making only. And you can bifurcate those so that you have a different person serving as power of attorney for business purposes than you do for power of attorney for healthcare purposes. The final document that I would suggest putting into place is a living will. A living will is a document that you sign if it's your intention that you would not want to continue to sustain your life if you were permanently vegetative, and two different independent physicians had examined you and come to a reasonable degree of medical certainty that you are permanently vegetative. In that event, the living will would instruct your physicians that you would want the life-sustaining treatment to be removed, and that's your ventilator and your feeding tube. So that's obviously kind of a weighty decision to make whether a living will makes sense for you, but I can say that for you to make the decision yourself takes the burden of making the decision off of your loved ones if, heaven forbid, something should happen to you and you do become permanently vegetative. So that's all that I have for you on estate planning, on wills, and powers of attorney and living wills. And I hope that you found some of the information that I presented today helpful and interesting.
Thank you. That was very good, Abby. A couple of questions, if you don't mind, if I could just ask. So you were talking about like power of attorney, living will, et cetera, et cetera. Is that, you do that all at the same time you're making out your will?
Yes.
Correct. And then, so because most of the time wills aren't read until a person has passed on.
Yes.
So how do you get access to that? Or if I've made that decision and I don't want to be on life support, or, et cetera, how does someone know that you even have that in your will to do that? Let's say my children have all passed or something, and it's just me and I'm, by myself now, and I'm 80 some years old. And when do you get to that point where someone can access that or know these decisions that we had made?
So the last will and testament is a separate document from the power of attorney for business purposes, which is a separate document from the power of attorney for healthcare purposes, which is a separate document from the living will. So they're all distinct documents. And what I tell my clients is that you should keep those documents in a safe place, and you should tell somebody that you love that you've had your estate planning done and where they can find your documents should they need to find them. And you're right, for usually with a last will and testament, it's not a document that is read or reviewed by your loved ones until after the funeral has taken place. So it doesn't make a whole lot of sense to not inform anybody that you have a power of attorney and your healthcare power of attorney, and just to keep those documents together with your last will and testament, because nobody would be able to find them or know of their existence if something should happen to the person who's making out those documents. Does that answer your question?
That answers my question. So if any of our listeners today would be interested in, speaking, with you about a will or an end of life, kind of power of attorney, et cetera, how do they get in contact with you? What do they need to do?
They can, I'm happy to help anybody who wants to put estate planning documents into place, and they just have to phone the office, and my phone number is 740-385-2181, and they can speak with one of my legal assistants to make an appointment, and either Kim or Sandra or Mary will be happy to help.
Okay. Are there certain things that they would want to gather together to bring to you, or do you have a form made up that they get ahead of time so they can get all of that together?
A great question. And typically when somebody makes an appointment with me to do estate planning, we have what we call an estate planning checklist that we send out to clients so that they know the kinds of things to be thinking about before they even talk with me, and that we can make the best use of our time together. So we send out that estate planning checklist to people when they make an appointment before our appointment time comes to pass.
Perfect. Okay. Well, thank you again, Abby. Appreciate you doing this for us today. And thank you to your listeners for joining us. Again, reach out to her if you have any questions regarding getting a will together. And we just appreciate you joining us again today. Thank you.
My pleasure. Thank you.
Thank you.